Welcome back, everyone. Today, we are diving into a really high-stakes, thrilling aspect of civil litigation here in Malaysia. We are looking at case reviews and enforcement of judgment A to Z. If you've ever wondered what actually happens after the gavel bangs and the judge rules in your favor, well, this explainer is going to be incredibly eye-opening for you. So picture this. You went to court, you fought a long, hard battle, and you won the case. Congratulations, right? But here is the harsh reality of civil procedure. Winning a trial absolutely does not mean the losing party is just going to happily hand over the cash. The court doesn't act as your personal debt collector. You have to actively take steps to enforce that judgment yourself. Here's a quick roadmap for this explainer. We're going to cover 1. The enforcement problem, 2. Time limits and finality, 3. Seizing physical assets, 4. Garnishment proceedings explained, and 5. Advanced enforcement tactics. All right, let's kick things off with Section 1, the enforcement problem, and understand the basics of execution. Just to make sure we don't get bogged down in legal jargon later on, let's lock down 3 absolutely crucial terms. The judgment creditor, that's the winner, the person seeking payment. The judgment debtor, that's the loser who owes the money. And a garniche is a third party, like a bank or maybe a business partner who is currently holding on to the debtor's cash. So the first critical hurdle is knowing what you can actually enforce. For execution purposes, you can only enforce a final judgment, not just any temporary court order. Our courts rely on the Borzon test, which the federal court actually adopted in the case of Harun bin Mohammed Zaid. The test asks a really simple question. Does this decision finally dispose of the rights of the parties? If the answer is yes, it's a judgment, and you can enforce it. But if it's just an interlocutory order, say a temporary order for discovery, you simply can't enforce it to get your money. Moving right along to Section 2, time limits and finality. Let's talk about the ticking clock of limitation. You see, the clock starts ticking the very moment your judgment becomes enforceable. From year 0 to year 6, you're pretty much in the clear. You can enforce it without asking for any special permission. But if you wait between 6 and 12 years, you hit a major speed bump. Under Order 46 Rule 2, you now need what's called the leave of court. Basically, you have to officially ask a judge for permission and explain why you delayed. And if you wait past 12 years, under Section 6.3 of the Limitation Act 1953, it is an absolute bar. You are entirely out of luck. This is brilliantly illustrated by the 1961 case of Dowd v. Ibrahim. It's a perfect cautionary tale. The plaintiff actually had an order from a magistrate for the defendant to transfer a piece of land, but they just sat on it for over 12 years. When they finally woke up and tried to enforce it, the court flat out refused. The limitation period had set in, meaning the right to enforce was legally dead. It's a huge reminder, do not sleep on your rights. Which brings us to Section 3, seizing physical assets. Let's look at writs of seizure, sale, and possession. Now, Order 46 can seem like this incredibly dense web of rules, but let's break the procedural steps down into a simple, logical staircase. First, if you're past that 6-year mark we just talked about, you get leave of court. Next, you file a precip, which is essentially a formal request, using Form 89. Once that's issued, the court sheriff or bailiff actually goes out and executes the seizure of the physical goods. Finally, those seized goods are sold at a public auction to pay off your judgment debt. Sounds simple enough, right? But there are limits. What's really fascinating here is looking at what the sheriff absolutely cannot take. Under Section 3 of the Debtors Act 1957, there are specific exemptions. You see, the law isn't designed to completely ruin a debtor's basic survival. The bailiff cannot seize things like wearing apparel, cooking vessels, beds, or even the tools of the debtor's trade up to a value of Rm 200. Pensions and wages are strictly protected too. It's an interesting balancing act between the creditor's right to finally get paid and the debtor's basic human needs. But remember, your execution must be built on a rock-solid foundation. Take the case of Liang Al Wang versus Neo Than Su. The judgment creditor here wanted to seize a piece of leased land using a writ of possession. To do this, they relied on a prior consent order between the two parties. However, when the federal court looked closely at that consent order, they realized it never actually contained a specific, explicit order for possession. Because that absolute prerequisite was missing, the writ of possession was totally invalid. Without a valid underlying order, your enforcement strategy will collapse. Details matter immensely. Let's move on to Section 4. Garnishee Proceedings Explained. This is all about intercepting third-party assets. So what happens if the debtor's wealth isn't sitting around in physical assets like cars or furniture? What if their cash is sitting in a bank account
or being held by someone else entirely. This is exactly where Order 49 comes into play, the garnishee proceedings mechanism. In a nutshell, the court intercepts money that a third party, the garnishee, owes to your judgment debtor. Instead of that garnishee paying the debtor, the court steps in and orders the garnishee to pay you, the judgment creditor, directly. It's a highly effective way to completely bypass a stubborn debtor.
Let's look at how this plays out in the real world, with the case of Kedah Kalangpapan SDNBH. Setting the scene here, the judgment debtor was a contractor. The garnishee was a third-party builder who had hired them. Now, the asset in question was a retention sum. This is money purposefully held back by the builder until a defect liability period expired, basically to make sure the building didn't fall apart after it was built. So the massive legal question for the court was, can a retention sum, which is inherently conditional, actually be garnished?
Well, the court's answer was incredibly decisive. They held that yes, the retention sum absolutely is considered a debt accruing due. Because it was a fixed sum that the debtor had technically already earned for work they had completed, the court allowed it to be garnished. This shows us that even if money is temporarily held back, courts will often still view it as a garnishable asset. But I should warn you, it doesn't always go that smoothly. Just look at Chongheng Long Goldsmiths. Here, the judgment debtor was a goldsmith who unfortunately suffered a robbery. The third-party garnishee was their insurance company. So the judgment creditor tried to swoop right in and garnish the insurance payout. But there was a massive catch. The insurance company was actively disputing that they owed the goldsmith anything at all, claiming breaches of the policy. The court ruled that because the third party legitimately disputed the debt, it just couldn't be handed over summarily. It required a full trial to figure out if the insurance company even owed the money in the first place. You can only garnish clear, undisputed debts.
All right, finally, let's look at Section 5, Advanced Enforcement Tactics. We're talking discovery, Anton Pillar, and committal.
Now, if you just don't know where the debtor's money is, you have two main tools to find out. First up, we have Order 48 discovery. You can essentially drag the debtor into court for an oral examination and force them to declare what they own. But alternatively, look at Section 4 of the Debtors Act 1957. This one has real teeth. Not only can you examine them, but under Section 4, the court can actually compel the debtor to pay by installments. And if they default on those, the court can commit them to prison for up to 6 weeks. That is a formidable threat to force compliance. But what if you genuinely suspect the debtor is literally going to shred documents or hide assets before you can even get them in for an examination? Enter the Anton Pillar order. This is an extreme surprise court order. When used in aid of execution, it allows your representatives to physically enter the debtor's premises, search for and seize assets or evidence. It's basically the ultimate legal ambush tactic, used when you have a real, justifiable fear that the debtor is going to make their wealth disappear just to avoid paying your judgment. However, with great power comes great risk. Just look at the case of Solid Gold versus Chan Wei Ho. In this case, an Anton Pillar order was obtained, the premises were raided, and over 400 videotapes were seized. But the defendant successfully applied to have the order set aside. And because it was set aside, the plaintiff, who rushed in with this super aggressive tactic, was found liable to pay damages to the defendants for a wrongful raid. The lesson here is clear. These extreme measures come with severe financial risks if you misuse them, or if you fail to disclose material facts to the judge. So we've walked through the timelines, the seizures, the third-party interceptions, and even the aggressive ambushes. I want to leave you with this thought. A court judgment is truly only as strong as your ability to enforce it. The law provides some incredible tools for creditors to get what they are owed, but it also provides crucial shields for debtors. Understanding this landscape isn't just for lawyers. It's absolutely vital for anyone engaging in business today. Take a moment to reflect. If you are on either side of a judgment tomorrow, are your assets protected, or do you know exactly how to go get what's yours? Thanks so much for joining me on this explainer. Keep learning, and I'll catch you in the next one.